హైదరాబాద్లో జాతీయ న్యాయ సదస్సు జరుగుతోంది. 2 రోజుల పాటు జరగనున్న సదస్సులో పలు విషయాలపై సుదీర్ఘంగా చర్చించనున్నారు. సదస్సులో సుప్రీం చీఫ్ జస్టిస్ ఠాకూర్ మాట్లాడుతున్నారు. ఇప్పుడు ఆ లైవ్ చూద్దాం.
But I think one of the major challenges before the legal service authorities in the country remain making access to justice for the poor a reality. We all know that in 1947, when this country got freedom, the total population was in the neighborhood of 35 crores. And even if 30% of that was taken as people below the poverty line, the number of the poor would be around 10 crores. The percentage of poor in the country continues to be around 30% even today. But the population has increased to 1.25 billion, that is 125 or 130 crores. So, those below the poverty line today are 4 times more than those who were below the poverty line in 1947. We have today 40 crore people below the poverty line. Primarily, our concern and our challenge is to reach out to that poor section of the society who are unaware of their rights, who are incapable of seeking redress, for whom justice or access to justice are both illusory, and therefore that challenge is something which I consider to be very, very formidable. Awareness about their rights is in itself something which presents a very major challenge. Conscious of that, we have over the past year and a half or 2 years tried to associate with our efforts the media. Earlier, we were not so much using the radio, the community radio, the television for purposes of dissemination of our programs or our availability or our support for legal aid. But over the past 1.5 years or so, we have been making use of that facility. And I must compliment those in the government for the positive approach and the positive role that they have played in making it accessible to us. But media alone is not enough. The involvement of the bar associations, the bar council, educational institutions, especially law colleges, is also a major area of our concern. We have seen in some of the states like Himachal Pradesh, in Jharkhand, in Haryana, partly in Punjab, educational institutions have been associated with the process of awareness programs. Small, very affordable kind of schemes which do not bring the entire system under financial stress or pressure have helped taking legal education to the grassroots. Improving the quality of the legal aid that we provide is another area. There is a general feeling that the kind of legal aid that we provide is not quality legal aid. There is a general feeling that only those who do not have any cases, who do not have any experience, who are not busy lawyers, they are engaged by us to be provided as counsel to the poor litigant. We have to overcome that challenge, and we have made some headway in that regard also. We have formulated training modules for training lawyers, legal aid lawyers, and I must tell you that that has taken off very well. The government has supported us. We have trained trainers, master trainers, who will then train the panel lawyers in their respective states. This training program was started in Delhi and it went off very well. I must compliment those who helped us, and I hope that the training programs will in times to come continue. Implementation of specific schemes is yet another challenge. Justice Dave mentioned to you that we have over the past 1 year formulated identified specific areas of concern. He read out to you the schemes that have been formulated. The importance of these schemes is evident from the fact that the Honorable Prime Minister was kind enough to come and preside over the launch of those schemes. There were certain misgivings in some quarters that the schemes that we have formulated are likely to come in conflict with what the state governments are doing. They may give a role to legal aid workers or legal aid functionaries that may bring the executive under pressure. But we have made it clear, not once, more than once, in almost all the occasions and conferences that we have had in the past, that our job in the matter of implementation of government schemes is only that of facilitators. What we are trying to say is this: if you have schemes, but the benefit of the schemes is not reaching out to the poor, then our job is to ensure that those who deserve their benefit under the scheme get it. Not by threatening the officers, not by using any other coercive means, but by persuasion. As a matter of fact, under the regulations of the state legal service authorities and NALSA, there are situations in which you can even file a public interest petition before the High Court. If supposing some authority, a governmental machinery was not to act in tune with the rights of the poor, or for enforcement of the rights of the poor, you can go to the court to get them enforced. That recognizes the fact that we do not have any right in ourselves, any power in ourselves to enforce something. You are only facilitating the benefit flow to ensure that the benefit flows to the beneficiary. But these schemes are, they cover a very large area. For instance, the scheme that concerns unorganized workers in unorganized sector covers a total of 46 crores in this country. 46 crore people are working today in unorganized sector. Out of them, 14 crore are women. And as Brother Dave mentioned, these people in the unorganized sector do not have the benefit of having an association or a union through whom they can agitate or coerce the employers to concede to them their rights. They are left alone. They may be working as domestic helps, they may be working as drivers, they may be working as helps in the waiters in the dhabas and hotels, where you do not have an organized machinery for agitation or enforcement of rights. Such large is the constituency. If you look at it from plain figures, you will see 40 crores below the poverty line and 46 crores in unorganized sector is the kind of constituency that you have. You are working in this constituency. It's a very, very large constituency. And when you have such a large constituency to cater to or live up to the expectations of people of such a large constituency, you need to put your heads together. You need to meet, you need to discuss, you need to rededicate yourselves. And that precisely is the purpose why we meet annually in one of the places where whatever we have done over the past is reviewed, our failures and our successes are evaluated, and we rededicate ourselves. But may I tell you that it is not just the poor that is our constituency. There's a general impression that only the poor is our constituency. I don't think that is correct. Legal service authorities are doing something very, very significant even in the other areas. For instance, a rich man is driving a Mercedes, is a rich man, and he is found speeding. He is challaned by the traffic man. Now, it is our duty to ensure that the fine that he has to pay is paid quickly. Facilitate the payment of fine quickly. So, Lok Adalats for traffic offences, where the citizens get quick justice. You don't have to wait, you don't have to wait for the summons to come, you don't have to go to the court to engage a counsel. You can evolve mechanisms, you can evolve methods by which even the rich can benefit from the quickness of the system that you have. Somebody has taken a big loan from the bank. He wants a quick disposal of his case or claim. We provide that opportunity. It is not just the poor. The rich can also come forward and say, I have taken 2 crores, I want to pay back, but I want some concessions. So we provide a pre-litigation Lok Adalat where a rich can also come and say, I am ready to pay. And in the process, over the past 1 year, I won't say over the past 20 years what we have done, the figures will be phenomenal. You may not believe them, but over the past 1 year, since February 2015 till date, we have settled claims of 5,855 crores in pre-litigation, where people didn't have to go to the courts. They didn't go to the courts. We provided the platform for a settlement, and the settlement took place. And those settlements are decrees which are enforceable. It is not as though it is just some kind of a voluntary or a promissory kind of a thing. No, it is a enforceable decree. 5,855 crores in pre-litigation and 8,462 crores in pending cases. Now, in terms of cases, if you see, we have decided 62 lakh pending cases by Lok Adalat, by mediation and so on, and 1.61 crore pre-litigation cases, which were potential cases that could land in the courts, but were settled because of the facility that we provide to the people. I think this is a great service not only to the poor for whom we provide free legal aid, awareness programs, assistance and all, and schemes that we have formulated for them, but also to relieve the judicial system of the burden that would legitimately fall on it if we were to close shop. If we were to wind up our activities, or if the Government of India, the Honorable Law Minister were tomorrow to say repeal this act, then the effect will be that you would have 62 lakhs plus 1.61 crores, 2 crores and 20 lakh cases reaching the court. The courts would be choked. Already we are told that you have 3 crore cases pending. I must mention to you, to the credit of the Honorable Law Minister who is here, that although there was this constitutional amendment which came under challenge, because of which the process of appointment got delayed, it got stalled for a while, and after the matter was resolved, the Law Minister, realizing that the process of amendment of the memorandum of procedure may take time, wrote a letter to me that the government is willing for the process to be resumed on the basis of the earlier procedure. And we immediately agreed. Within a period of 4 weeks or so, 6 weeks, we cleared nearly 163 names that were struck for more than a year with us because of the controversy regarding National Judicial Commission. And I must compliment the Honorable Minister that out of those recommendations, about 90 appointments as permanent judges and about 40 appointments as fresh appointments made to high courts have already come through. The others are in the pipeline, and every time I meet the Honorable Minister, he tells me that he is taking personal pain, he is going to the PMO, he is trying to tell people that while the process of improvement of the system by way of amendment of the memorandum of procedure can go on, appointments in the judiciary cannot be delayed, because we have today something like 450 vacancies in the high courts to be filled up. And over this year, there will be another 50, which will take the total number to 500. The system is under great pressure, which I am very happy to tell you is also appreciated and realized by the government. There are, after the process started, I wrote a letter to the Chief Justices, and I believe about 130 names have already been recommended from various high courts, which are in process with the Law Ministry. And I am sure the Honorable Law Minister, who is a very, very conscientious and very, very polite and friendly person, it's such a pleasure to work with him, is going to process those, because he realizes that while we are in the process, or we are open to improvement of whatever the procedural angle is, the process of appointments must go on. Because access to justice is something which has been recognized by the Supreme Court as fundamental. It's a fundamental right of a citizen to access justice. And if you are not to appoint judges, you are actually depriving people of their fundamental right. That's something which is totally unacceptable. And this, I believe, if in this scenario, in this background, if you look at the kind of work that the legal service authorities are doing, in as much as we are relieving the system of something like 2 crore cases over a period of 1 year, which would ordinarily land in the courts, I must say that we are making access to justice a reality. I must compliment all of you for your commitment towards this cause, and for coming all the way from different places despite your, you see, preoccupations in your own states to attend this conference under the dynamic leadership of my esteemed brother Justice Dave, who is a very conscientious judge himself. I am sure this process which has